And hello, ladies and gentlemen. Thank you for joining us this morning. Let's see. Right now, nothing's going on. I am going to dip in uh, occasionally and let you know what's going on or add commentary. I'll bring the screen up, but nothing's happening here yet. So I'll show you the screen that we're looking at, and boop, that's it. So this morning, Matt Larossier, Matt Hoover's attorney, is going to be uh, doing the oral argument, which is going to be streamed live from the courtroom in Jacksonville. And as of now, we got nothing from those people yet. So they initially said it was going to be 9 a.m., and then they said it's going to be 8:30. My experience, a lot of times courts will get people together a half hour before they actually do anything. I'm not sure if that's what's going on right now. Uh, Guys, let me know. Put a one in the chat if the audio is good, everybody's hearing me good, and that things are looking good here. And in case you don't know who I am, I'm not Erica, and I am not Matt Hoover. I'm a friend of Matt's. My name is Richard Hughes. I go by Flying Rich on YouTube. So, okay, I got 5x5s. Thank you, folks. Thanks. I think Matt is on lockdown right now. Excuse me. I've actually, usually I only email with Matt through the prison system, but Matt has given me a call a couple of times in the last couple of weeks, which, I really appreciate because he only gets so many minutes to talk on the phone. And, you want to talk to your family, almost like I tell them, don't call me. Talk to your family, talk to your kids. It was one of his daughter's birthdays, I believe yesterday, or it might have been Monday. It was Monday or Tuesday. I'm sorry. I'm getting my days mixed up a little bit. So, Erica was hoping that Matt was going to be able to call and wish her happy birthday. And, and that's Erica. So, Erica's on the CRS Firearms. How's it going? On the 9th, yeah. So, Matt's been trying to call them on their birthday, wish them happy birthday, and talk to his kids. You got to realize how tough this is for a family being separated. They talk about splitting up families by deporting people that were illegally in the country, and I love what Tom Homan says. He's like, deport them both, but deport them as a family. But this is really bad. Matt loves his girls, loves his wife, loves his family, and Matt decided what he wanted to do is YouTube because he wanted to be home with his family, and that's just so amazing to me, and it's so sad that this is how it ends up. Alrighty, guys, I am going to drop out for a moment here, but I'm going to leave the screen up and I'll dip back in as anything occurs.
I just wanted to pop in. I'm John Crump. I'm another one of CRS's friends. The court case should be starting shortly. Courts never start on time. Usually they get people there early, so when the judge comes in, he can makes his entrance and everything else. So once that starts, they'll turn on the live stream and we'll be able to cover it. So right now, nothing is happening, but we'll get oral arguments today. We probably will not get any type of ruling today. They'll listen to both sides, the federal government side and Matt Larossier, who is CRS's attorney, better known as Fudbusters. And then we will get a decision sometime later on down the road. There isn't exactly a time frame for that decision to come in. We'll just have to wait. The judges will hear both oral arguments. They'll do a written response, basically saying whether the appeal is successful or not, and then we will go from there. Even if the appeal is not successful, there is still other steps that can be taken by Matt's attorneys to further alleviate his sentence. They can go to a higher court, which is the Supreme Court. They can do some other stuff. But as of right now, this is a chance for Matt to win an appeal and get all his rights back. I talked to Matt a few times over the last couple weeks, including when I was out of the country. He seems in good spirits. He can't wait to get home, and we are praying for him, Erica, and everyone in his family. So I'm going to drop off here. Just wanted to give you an update since there's nothing going on, and just to make sure that you guys don't think that the screen is locked up or anything like that. While we have a moment, tomorrow, Larossier is going to be in Virginia, different part of Virginia than what I'm in, but he will be arguing Tate's case. Tate is a Navy soldier that was convicted for having a machine gun, even though it was just like a parts kit, and an RPG, which wasn't really an RPG. The ATF rebuilt an RPG, a hole drilled in it, no trigger pack or anything like that. They welded the hole shut, uh, installed a trigger pack, and then fired a dummy round. Basically, it was like a RPG round, but instead of shooting an RPG round, it was just like a little 308. That case is tomorrow, and I'll be streaming that on my channel. I believe that it probably will be. I think I will be. That is at 8:30 tomorrow morning over on my channel, which is John Crump News. Both Matt and Tate are being held unjustly by the US government. So hopefully they'll both get off and be able to walk free. Exactly. Tate case is interesting because the federal government had a CI purchase a parts kit off Gunbroker and sell it to an FBI undercover agent. Tate was of the belief that the parts kit was demilled like it should be. It was on Gunbroker, for God's sake. Unfortunately, instead of having blowtorch cuts, it was bandsaw cuts. and the ATF considered it to be a machine gun under the NFA and charged him with an NFA violation, even though that there's no way he could comply with the NFA because they shut down the machine gun registry and would not let you pay the $200 tax stamp, which is what he's being charged for, which is crazy. Rich is off doing morning stuff. He's a little bit under the weather. So when I called him, I woke him up. Process is definitely the punishment. There is another case, uh, family friend named Latoya that's being charged with murder for killing her abusive husband in Virginia. That case is interesting and also sad. Latoya's ex-husband threatened to kill her and her family. He showed up unexpected, broke into the house, a scuffle happened, he was shot and killed. He was defending himself, and Latoya is being charged with murder. So that's another case where it's it's just crazy. Growing up, I used to think that prosecutors were the good guys and the defense attorneys were the bad guys. And as I got older, I realized that it's the exact opposite. Not only that, but prosecutors really don't care about justice. They're supposed to be here to defend justice and get justice. But prosecutors, what they care about is getting that W. They care about getting that W to advance their own career. And yeah, Matt Larassier is still CRS's attorney. He will be doing the oral argument. Laura Crawford Taylor, particularly, is evil. That's my opinion. That's not Matt's opinion or anything else's opinion. It's just mine. Yeah, there's no guarantee the courts will agree. Um, I can never. I can never tell what the courts are going to do. No one can tell what the courts are going to do. No matter what you think, the courts do. Um, can do what they want, and they do what they want. And sometimes they do something that's surprising, and sometimes they do stuff that isn't surprising. Just you never know what you're going to get. Anyone that tells you they know what the courts are going to do 100% is not in the know or really don't understand how the courts work. I've seen liberal courts give very good judgments. I've seen conservative courts give very bad judgments. It's just the way it works. No one really knows exactly what the court's going to do until they do it. I just got some information about the whole Charlie Kirk thing. I'll be going live with it later once I verify it. I don't want to put out any bad information, but it seems legit. I'm gonna drop off here for a second. Be right.
Well, okay, the screen has changed. So it does say live. Looks like they're getting prepared to stream. Usually there's a little bit of briefing, conversation, maybe some motions that are going on. Eagle Run 23, what's up, my homeboy? And if you want your own Donald Trump mugshot mug, now his portrait, presidential portrait, you can get it on my YouTube channel. Bruin Flight, how's it going, man? So yeah, I gotta confess, I set the stream up. I've been sick the last 2 days. I'm feeling a little better, and I did not set a wake up and plan on having this all set up and done. So I have to apologize, but it doesn't look like we missed out on anything because of my lack of planning. And Erica's asking if I can see her comments. I was seeing your comments under the CRS user account. You said Christopher is there, though. Christopher is there, though. Okay, so Christopher's on site. I'm assuming Matt, meaning Matt Hoover. If just to keep everybody unconfused, I'll say LaRossiere for Matt LaRossiere, Matt's lawyer, and I'll say Matt for Matt. I know Erica calls him Matthew. Yep. Yeah, Erica, we see your comments. So I talked to Matt. Oh gosh, I don't know if it was Monday or whatever. It's always it's a DC number. It comes in a federal prisoner, an incarcerated individual is calling. It's like, oh gosh. And I swear they burn up as much time as they can by talking. And it's like, press 5 to accept this call. And it's Matt, this was very important for Matt that you guys get to see this. So he's like, hey, make sure it's out there that everybody can watch it. So that's what we're doing here. And look, it's been tough for Erica. I'm not going to share. Erica can talk about stories herself, but
we have 4 appeals to hear this morning, counsel. We're familiar with your cases. We've read your briefs, the authority cited in your briefs. We've looked at the record. So you don't have a lot of time, 15 minutes per side. Please get straight to the heart of your argument. We're probably going to have some questions. But be mindful of the traffic lights, and when the red light shines, that it's time to stop. If you're answering a question from us, of course, you can finish your answer. You'll be on our time. So if you've got rebuttal time, you won't lose it by answering our questions. But be mindful of the time. We're going to begin this morning with United States versus Irvin. Ms. Lennon?
May it please the court. My name is Valerie Lennon, and I represent appellant Christopher Irvin. He's also known as Justin Irvin, and he is seated behind me. From the outset, I do need to concede that the sentencing issue is no longer before the court. It was disposed of by the United States Supreme Court in the Curtis Brown case, which also came from this court as well. Also, in my duty of candor to this court, the government filed a notice of supplemental authority last week for the Sixth Circuit case of United States versus Bridges. There was a virtually identical case from the 10th Circuit late last week in United States versus Morgan. Both of those cases involved a Glock handgun that had been modified with an auto sear so that the Glock would fire more than one round with a single pull of the trigger. So in my limited time here, I want to make sure that the court understands the spectrum of what we are talking about here in this case. On one hand over here, we have Bridges and Morgan that have a fully operational Glock handgun that with one pull of that trigger could have fired more than one round on those officers. Fully operational. In this case, we have the functional equivalent of an Apple titanium credit card, which is what I'm holding in my hand here. It's within a millimeter of the same dimensions as the 1-in-1 auto key card, 2-in-1 auto key card, and substantially the same composition. So to go from here, from the auto key card to those Glock handguns or to a machine gun AR-15 modified on this side, here's what had to be done. Here's what Agent Toy testified.
I think we know what the object looked like. I've got a photo of it. We've looked at the record. It's really not that card you held up, though, because as as we all know, there are etchings on here. This is metal. I don't think we really have any doubt about what the object looks like here.
Sure. So still to go from that object, that metal business card, metal credit card, auto key card, that auto key card couldn't be inserted directly into an AR-15 to make it fire more than one round with a single pull of the trigger.
But does it constitute a combination of parts designed and intended for use for converting a weapon into a machine gun?
No, Your Honor.
Well, of course, the jury thought otherwise.
Your Honor, that was a question of vagueness that needed to be decided by the district court. Questions of law have to be decided by the district court. Questions of fact can be decided by the jury.
So is this about your argument about the jury instructions?
No, Your Honor. In Mr. Irvin's brief, the first argument was vagueness. I'm not sure which one that was in Mr. Hoover's argument.
Yeah, one of my confusions about that is there's an argument that on the one hand, there's the argument that this was the statutes, the terms of the statute were clear, and it's clearly doesn't cover your client's conduct. Which would suggest to me not vague. But then there's an argument about vagueness and a suggestion that because it's vague, we would apply the rule of lenity. Well, the rule of lenity is not something that comes into play for vagueness. The rule of lenity comes into play when there's ambiguity. And the argument that, as I understand that you've made, is that it's not ambiguous. So you understand the difference between ambiguity and vagueness? I'm having a hard time following this argument.
So vagueness is the argument that was before the district court. If I inserted ambiguity into the initial brief, then I misspoke.
A rule of lenity then would have nothing to do with it.
Correct, Your Honor. And to be clear, we are not asking Congress, or we are not asking this court to rewrite the statute. We are asking this court to enforce the statute as it is written, which
then that would suggest that it's unambiguous.
The statute does not include precursors to parts, and it does not include raw materials, which is what we have here. This card is at best a precursor to parts, not a combination of parts that can be, we can't even use a screwdriver to pop these parts out. put them directly into an AR-15 to make it fire with a single.
All of the evidence the government introduced showing that not only did your clients understand that the combination could result in a machine gun, but videos that suggest that they were acknowledging to potential customers the other use of those materials or parts.
Your Honor, my time has expired,
You can answer that.
So I believe the video that Your Honor is referencing is the one of Mr. Hoover talking about how the parts worked, if I understand the question correctly. And in that video, Mr. Hoover was simply having a First Amendment discussion about his Second Amendment rights. He did not instruct them about all of the extras that had to go into how to cut that out, the specialized knowledge about how to hand fit it, that the one that he was referencing, the actual auto key card part, was not specific to any actual long rifle. The government's own experts testified that this was a generalized
What
drawing.
is the First Amendment message here?
The First,
See, the problem I'm having with that is the First Amendment doesn't protect speech that is about a crime.
but if there's no crime, then it's
Well, that's a
Still
different
free
question,
speech.
but that just brings us back to that, not to the First Amendment.
Your Honor, I am way past my time.
I have one question for you. In a different context, in Bondi v. Vanderstock, and that was dealing with the challenge to an ATF rule, so a different context. But the Supreme Court noted that a weapons kit was still a gun, even though a little work is required to complete them. Does that language work against your client?
So when we're talking about a little work, we're not talking about specialized knowledge, 53 minutes with a Dremel tool, belt sanding, grinding wheel, drill press, hand file, and then inserting a machine gun bolt from the 1980s to make it work. That's the spectrum of modifications, machining, manufacturing, and fabrication that had to happen in order to convert this metal card into a machine gun combination of parts to fire with more than one, with a single pull of the trigger. If there are no further questions,
You've saved the one, or you haven't saved any time, Ms. Lennon. Thank you.
thank you.
Let's hear from your co-counsel, Mr. Hoover. Laurasuri, is that, how do you pronounce your name? I'm sorry.
Rossier, Your Honor. I apologize.
You don't have to apologize. I apologize.
I always apologize for being Fred.
Fair enough.
May it please the court. I'm Matthew LaRosier for Appellant Matthew Raymond Hoover. At base, we have to take a step back and remember that this prosecution is built on a proposition so extraordinary that it should give this court pause. And that's the idea that a drawing is a machine gun. At base, and I'd like to touch on Vanderstock, and I'd like to touch on those other cases as well, but we have.
It's more than a drawing. It's a draw. When you say drawing, I picture a piece of paper with a drawing on it. This is a metal part. It's a metal card that can be used if it is cut out, and it has not just a drawing on it, it has an etching. And in some of the cases, you could pay for this card, you could pay more to have the more complicated part, the interior circle, cut out in advance. So it's more than a drawing, right?
Your Honor, no, it is not more than a drawing. And in fact, it's undisputed that these cards were homogeneous, singular pieces of stainless steel. It's also undisputed that the drawing was so light that it could not catch a fingernail. This isn't the same as the government put in their response brief, a puzzle that you can pop out with your thumbs. Not at all. This is a homogeneous piece of steel. And the canvas doesn't change its composition.
I think Judge Branch's point was it's not a drawing on a piece of paper. It is on stainless steel, right?
Yes, Your Honor.
It's not just a drawing. It's an etching on stainless steel that's true to scale for what would be required for a converter for a machine gun. It's not, feet longer than that. It's the right size, the right kind of material, and a true to scale etching, right?
No, Your Honor. Respectfully, it's undisputed also that it is not true to scale. In fact, it is undisputed that Mr. Toy, the government's expert that much of this case is built on, only built a device, which he admitted did not function the way he expected it to, by cutting outside the lines. And so if we are to understand that the lines transform this canvas, this piece of material, into something else, I don't understand how we can go from the lines somehow turning a homogeneous piece of steel into a combination of parts to then also saying, well, the lines don't really matter that much. He just went outside the lines a little. That's absurd. It's Kafkaesque to suggest that this drawing is a machine gun. It's not even a part. It's undisputed, homogeneous. And again, we're not asking this court to rewrite the statute. You can see it in the government. Sorry, you can see it in the lower court.
So this all goes, you say because of that argument, there's insufficient evidence.
This is not a sufficiency of the evidence question, but this is a sufficiency of the indictment question, where the indictment said that this is a singular piece of steel, and then it was indicted as a combination of parts. That's internally inconsistent. When the government, at the close of the government's case, when motion for judgment of acquittal was made, the lower court recognized the homogeneity of the steel, and the lower court recognized that it had to be materially altered to become whatever it is that Cody Toy tested. The statute simply doesn't cover that. And insofar as Vanderstock goes, that was, again, a question of a facial challenge to a rulemaking. It's very different from a first impression criminal prosecution against an individual who was, in the case of my client, talking about a drawing, was advertising this drawing. And
Okay, well, let's say we don't agree with you that this is just a drawing based on what Judge Branch has already stated. I'm more interested in the combination of parts piece because your co-counsel talked about a spectrum as well as all of the steps that are required to result in a machine gun. And my question is, how many steps are too many steps in your estimation to not qualify as a combination of parts? I mean, 1, 2, 3, that seems, and then a machine gun. Where's the line that you're supposing? Because the statute does mean something and it does target some conduct, even though you're claiming not your clients.
absolutely, Your Honor. And the statute has 6 or 7 different definitions of machine gun. The government chose to proceed under this one, requiring a combination of parts. When you're going to use that specific section and you have a single homogeneous component, I think wherever that line is to be drawn, it's beyond homogeneity. It is where there, respectfully, Your Honor, I think it shouldn't be too controversial to say that a combination of parts, plural, should have some independent components within it, should have something that's mechanically separable. The statute doesn't say designed to become a combination of parts. The statute doesn't say something that contains parts that can be accessed through material alteration. It says a combination of parts designed and intended.
But to Judge Abudu's question, where is the line? What, you wouldn't be here if
I think he was
what
clear
facts
about
were
that.
Present. Presumably, you pointed to the government in its briefing had the puzzle pieces that popped out. Presumably, you wouldn't be here arguing today if the card had the etching was so deep that somebody could just pop the pieces out, correct?
Yes, Your Honor, I see what you're saying, and I agree. If the parts are distinct from the whole, as is the case in the government's puzzle analogy, it would be a much more difficult argument to say that they were not a combination.
So at some point, the etching becomes deep enough that it takes away your argument that this is a single part, right?
Certainly, but wherever that point is, it's beyond the point a fingernail can start to catch it.
Yeah, but isn't that then wrapped up with a factual inquiry, effectively, about whether that combination is designed or intended for use in converting a weapon into a machine gun, all of which was then put to the jury and the jury made a finding?
Your Honor, there are combined questions of law and fact, but no reasonable jury properly instructed. And again, because the government insisted on proceeding with the combination of parts theory, the fact that the court refused to instruct the jury that if it was a single part and not a combination of parts that they must acquit, that compounded the issues here. And Your Honor, I'm about to run out of time. May I say one more sentence?
You,
I would just like to point out that the government makes much of his case talking about state of mind. And I know Your Honor, Abudu made that question. Even a mountain of mens rea evidence does not excuse the government from proving a chargeable actus reus. And for that to be the case, there must have been a combination.
thank you.
Thank you.
I think we understand. You've saved 3 minutes for rebuttal. Let's hear from the government.
Morning, Your Honors. May it please the court, Sean Siakinen for the United States. What I've just heard right now is a little different than, well, much different than the evidence that was presented at trial. I'd like to respond to some points that come up. And the first point that I want to make is that one reason that the jury reasonably found that the auto key card was a machine gun, was designed and intended to be a machine gun conversion device, including a combination of parts, is that that is what Hoover and Irvin told everyone. And in particular, Mr. Hoover told his viewers that the auto key card was a lightning link, which is the machine gun conversion device in question. He told his viewers that it would let them, quote, make a machine gun, quote, experience full auto, and quote, scratch their full auto itch. Then he explained step by step how to cut out each separate, discrete piece, insert the two pieces into each other to form that bracket, which is what the lightning link is, and how to fit that assembled device over the bolt carrier in a weapon to generate automatic fire.
What about the size? Was it true to scale?
Well, at a minimum, that was disputed. It certainly wasn't undisputed, as I just heard right now. And what the testimony showed was that the ATF agent who cut out and assembled these devices in 40 minutes or less had to trim or file less than a millimeter off of one edge in order to fit it into one particular weapon that he tested the device with. And the reason for that is that there are tolerances involved in each different rifle has different tolerances. And in order to fit it into that particular weapon, yes, he had to slightly file it down a bit. Perhaps he would not have had to do that if he had been using a different weapon. But another point that I would like to make on this is that the statute does not require functionality. A machine gun conversion device is
Has to be as designed and or intended use.
exactly. And so when you look at all of the evidence in the record, I don't think that the district court or the jury could have or should have looked at this device in a vacuum. I think that they reasonably and appropriately considered all of the evidence, which included Mr. Hoover's own words to his viewers, to his customers, Mr. Irvin's own words, all of the evidence. And when you look at the full context of these devices, including the materials, the markings, the advertisements, the implicit and explicit instructions, I think the evidence of the device's design and intent was overwhelming.
Can I ask you, as I asked opposing counsel, where is the line? If we have a metal card, for example, that somebody just took a Sharpie and drew true to scale these designs, are we having this prosecution today? Is that a combination of parts?
I think if you just had the card with drawings on it without all of the other evidence, including the instructions, the demonstrations, then it would certainly be a more difficult case. And I think that is why this is a question for the jury to decide. I also think that Vanderstock is helpful on this. As you mentioned, Your Honor, the Supreme Court recognized in Vanderstock that unfinished component part kits can be weapons under a different statute. And one of the reasons that the Supreme Court held that is that artifact nouns such as weapon, or in this case, part, are commonly understood to include their intended use, and therefore an unfinished, incomplete version of an artifact noun would usually be understood to satisfy the definition in the way that an unfinished table from IKEA, or an unfinished novel, are understood to be a table and a novel. No different with weapons or parts, I don't think.
So to your point about Vanderstock, Vanderstock does mention that a novice was able to do some work and make that into a machine gun. Here, I'm sure you would concede the work,
No one
the
did it.
work that was involved exceeds what a novice would be able to do.
I'm not sure I would concede that because the ATF agent testified that he had no metalworking experience. So the ATF agent certainly was not a novice with respect to firearms, perhaps, but I don't know
But
that.
as to the skill of cutting this metal to create the lightning link, he was a novice.
Exactly. And the record also shows that the tool that he used was a commonly available Dremel that, you know, anyone can get from any hardware store. So I don't think it's fair to say that the ATF agent who cut this device out was, you know, had any extraordinary or expert experience or knowledge in metalworking and how to cut the device out. And again, I don't know that that matters because functionality is not an element of this offense. All that matters is whether these devices were designed and intended to create automatic fire.
Yeah, I used disjunctive earlier, but it's designed and intended, right?
Yes, exactly.
What about the number of steps from the
But it's not
card to
designed.
actual functionality, even though that's not required, or conversion to a machine gun? How many steps are too many steps to make it a combination of parts for purposes of that outcome?
I think that's a fair question, and I think that's a fair factor that juries should consider in deciding whether this element is met.
That's his catch-all, the jury.
In this case, the steps were simply cutting these two parts out, inserting one into the other, and
No,
Was your answer that that's really a factual inquiry that's reserved to a jury, not a legal inquiry?
absolutely.
And both you and the other side mentioned the amount of time it took to construct this firearm. Does that matter? How much time? What if it takes a real novice 5 hours? Does that matter in terms of its intended use?
no
Again,
novice
I would say
did
it's
it.
not this positive, but it certainly could matter to the fact finder, which I think should be the jury in this case, where
That's his catch-all.
dealing
I don't
with
know. Jury.
an element of a criminal offense specified in statute to be proven beyond reasonable doubt to the fact finder.
This guy's a good actor.
I think all of those things,
But the facts could be such that at some point, a court could determine that no reasonable juror could find, as a matter of fact, that it was designed and intended. for that use.
certainly based on the evidence presented, and that determination would have to be made on all of the evidence.
Sure.
As the district court ruled in this case in denying the defendant's Rule 29 motion. But to respond briefly to a few of the points that came up earlier, Mr. Irvin's counsel said that this device was basically a credit card, and I would just point out that if they had engraved 2-scale functional component parts on a credit card and instructed their viewers and customers how to cut them out, how to insert them into a semi-automatic weapon, and told them, as Mr. Hoover did, that this is a machine gun and a machine gun conversion device, then it would be no different. I think that would also meet the statutory definition, or at a minimum, a jury reasonably could have so found. On the vagueness point, the Fifth Circuit decision Campbell cited in our brief, I believe, decides this and is binding authority on that point. The statute, this provision has been held not to be unconstitutionally vague. Mr. Irvin's counsel conceded that the rule of lenity has no bearing here. We would agree with that. On Mr. Hoover's videos, I would say that they not only suggested that this device could be used as a machine gun conversion device, they went several steps forward, and he explicitly told his viewers, this is the machine gun. The main benefit of this device is you cut these parts out, you create your lightning link, you drop it in, you take it out, and nobody has to know about it, and the only machine gun is this part right here pointing to the lightning link. And he told his viewers that if you do this, you'll be a felon, so don't tell anyone about it, don't record yourself doing it. So I think the evidence was there was more than sufficient evidence from which a jury reasonably could have concluded that these devices were a combination of parts designed and intended as machine gun conversion device. I see you have a few more minutes. I just have
You don't always have to use it, you know.
One last point. Well, we did already talk about, we already talked about that. The last point I would make is that the auto key card is clearly more than just a drawing. Defendants did not manufacture this on cardboard, on paper, or on thin plastic. They manufactured it on a strong and durable material that would work, that the ATF test
Never has
proved
worked.
to work, and that evidence was before the jury. So I don't think it's fair to characterize this as just a drawing.
Can you touch on the Second Amendment claim, even though they didn't argue it in the first instance? In the alternative, they argue, I think, that the statute itself violates the Second Amendment. What is your response to that beyond just a citation to Bruin and Heller in those cases?
In addition to Bruin and Heller, the supplemental authority letters that we submitted pointing to decisions from other circuits recently holding that the Second Amendment does not stand in the way of the government restricting machine guns or machine gun conversion devices because those are dangerous and unusual weapons.
And then I think their argument is that that language is outdated.
Well, the Sixth and the 10th Circuit cases that we cited in our 28J were issued within the last couple of weeks. I don't think the language is outdated. There are the appellate courts that have looked at this issue recently have uniformly concluded, to the best of my knowledge, that machine guns, including conversion devices, when courts have addressed them, are dangerous and unusual weapons and therefore beyond the scope of the Second Amendment. And I'm not aware of any appellate court decision going the other way.
Thank you. We understand your case.
Thank you, Your Honor.
May it please the court. Matthew LaRosier for Matthew Raymond Hoover. I would just like to touch on this again as to Toy's inexperience. Record shows Toy was a Marine Corps armorer. So to the extent that they're contending that this could have been done by any particular person, that evidence just isn't before us. But the real question here is one of law. Something's status as a machine gun, at the end of the day, is a matter of law. And by the time the court denied the motion for judgment of acquittal, before it, again, the court even in its order contemplated that it was a homogeneous component, uniform, single, that it had to be materially altered. At that point, it should have been, the motion for judgment of acquittal should have been granted. They charged a combination of parts. There's other parts of the statute that don't require that. They could have charged it in the alternative. They didn't. And just as we, again, to quickly point out, Hoover does not cede lenity. The question of ambiguity here is that we think that the statute very clearly does not cover a homogeneous piece of steel with a drawing.
Lenity has nothing to do with fake.
Ambiguity.
Okay, which is it?
So if
An argument about, is your argument that the statute's ambiguous or is it vague?
Your Honor, I understand. The argument is that if this section covers whatever the auto key card is, then it's incredibly ambiguous as to that and needs to be construed narrowly to avoid the absurd result that we have in front of us, that somebody in a first instance type of criminal.
So for it to be ambiguous, there has to be more than one plausible interpretation.
Yes, Your Honor.
And if we're going to employ the rule of lenity after using all the other canons of interpretation, if ambiguity persists, we have to choose the plausible interpretation that favors the defendant. What is the plausible interpretation you're talking about, as opposed to a vagueness argument where we can't know whether we're on one side of the line or another of illegality? That's a different argument.
Yes, I understand, Your Honor. And again, many of our arguments were brought in the alternative. Again, we assert that the statute is clear and that something that is homogeneous can't, right? However, if the court,
In which case, no rule of lenity.
however, if the court finds otherwise, if the court finds that a combination of parts could, as the lower courts contemplate something that could become a combination of parts, then there must have been a competing interpretation, and thus statute is vague or ambiguous.
That must have been as what? There must have been that interpretation. Well, what is that plausible interpretation?
This is exactly why it was brought in the alternative. And the way it was stated was that if the court finds.
It's a confusing thing to follow when you argue that it's unambiguous. But if not, it's ambiguous rule of validity. If not, it's vague. I'm not exactly sure, though.
Let Matt
what the
talk.
Argument is once you get past your argument that it's just unambiguous.
Your Honor, I see I've run out of time.
You can answer that.
Your Honor, I do think it's clear from the record and from the briefing that the way this is brought, if it is not clear, if the court finds another plausible reading, well, then it is ambiguous.
Okay. I think we understand your case, and Ms. Lennon, note your court appointed. We thank you for accepting the appointment. We're going to move on to the second case, RLI.
All right, that was it.
So I really wish Matt could have completed his sentence and explained that combination of parts is not a part. You know, and that's where it's ambiguous, and the rule of lenity would apply. Is that, hey, this is a single homogeneous item. And if the rule says combination of parts, the rule did not I should say law. It's not a rule, not an ATF rule. The law didn't say combination of parts or part. It said a combination of parts.
Yeah, I mean, we will have to wait and see what they come back with. A lot of times, how do I say this? A lot of times, like, you think they're going to go one way, but they go another way.
And I just want to caution
they
the audience in how they were communicating here. And I'm, freedom of speech, and I'm not saying that. The people that were saying, hey, this is a circus and a crap show and all that bit. As a judge, you want to hear both sides, and you want to get the information from both sides. It's like, if I was going to find for your client, what would I say? If I was going to find against your client, what would I say? And to hear both arguments so they can make a decision. So don't, like Crump said earlier, you cannot count on what you heard as to be what the judges will do. So it's a very interesting case. These things, I hate that we're going to have to wait some undetermined amount of time. It's I think Matt argued very well. I actually
will say that Matt did a great job. I don't know if the judges were open to his argument, but he did a great job.
I think that the judges asked questions on both sides. And if I were a judge, I probably would have asked very similar questions. And I'm just saying that.
I got the feeling that they had their mind made up, though. But I could be wrong. I never know what the judge is going to do.
First off, AR-15s are mil spec. So to say that something is or isn't in spec, and kind of talking a tolerance stacking argument, and that's why you had to file it, I disagree with it. And if he's incriminated on the basis of, so the hierarchy of evidence against them seems to be more that it was advertised as a lightning link. That seems to be the main claim that they have. And after that, whether it functions or not, or whether they believed it was, and the thing that bothers me about this is they're saying like in under an hour, the ATF made it a machine gun. But all of the people that testified that they brought in 4 people that testified they bought one and weren't able to make it work. So it just seems to me that I find it in bad conscience that they're hanging their hat on the idea that if it's advertised, if I say, this is a machine gun conversion device and sell it to you, that all of a sudden I'm guilty of, nobody certainly would take a, USB Ethernet adapter as a machine gun device, conversion device. And it's just preposterous to me.
Yeah.
But
Yeah, definitely.
unfortunately, so the bad part about this is it's going to be totally unsatisfying because it's not like Matt runs free from the courtroom like you would see in a movie, or we're not going to know for 30, 60, 90 days until they turn out a decision.
Yeah, at minimum.
And Crump, I'm assuming you read the appeal that Matt LaRossiere filed?
I did.
And I know I've heard other people say it was good. I don't recall if that was you.
Yeah, it was good.
And it did seem to me that the judges, at least one of the judges, read the appeal, so they were familiar with the content.
They all read it.
Yeah, so it seems to me that they were familiar with the content of it. So that makes me feel good. Like, 1, LaRossiere had a good appeal, and 2, that they read it. And usually the oral arguments are, just like a Supreme Court oral arguments, it's just to get any questions aired out.
Yeah, but we're gonna have to wait and see what happens here.
And Eagle Run said, "Got the kids to school. What I miss?" It's like, again, it's not conclusive, so you can go back and listen to it. You might be frustrated or entertained, but that's how it goes. Oh,
Yep.
Okay. So Aerial Innovations, thanks for commenting on this. Dangerous and unusual. Well, how many machine guns are there out there? And what was the law? It was a taser law about dangerous and unusual.
500,000. 250,000. The government claim. Okay, NFA registration shows 750,000. Some courts have said that's overblown because there's blah blah blah. We're not sure all these are still in circulation, so we only think it's 250,000. What a lot of courts have tried to do is they try to say that the stun gun thing doesn't apply because it's the percentage of percentage of guns that are machine guns makes it unusual.
Oh, wow. That's an interesting way of skinning the cat.
Well, that's what a lot of these courts are doing. They're saying, well, yeah, there's more machine guns than stun guns, but they're only a small percentage of firearms in circulation.
Uh-huh.
So they go from raw numbers to percentages.
Gotcha. Which nobody's used a percentage in the past when contemplating dangerous and unusual.
Yeah. Yeah. I don't think there's much more we really can say. We just have to wait and see now.
Alrighty, guys.
I got to go work on some other stuff. So yeah.
Enjoy
I got to
your
go
day.
configure some Cisco 9Ks.
Enjoy your Cisco 9K, unlike a suppressor that's a 9K.
Yeah. All right, cool. All right. I will see you guys later. Bert, you want to end it?
Yep. Ending.